Great, so nice to see you all after a one-week hiatus. Happy New Year to all of our friends who are in the Jewish tradition. David Greenstein is not here with us this evening, so I get to introduce myself. So without further ado, Akhil Amar. We're in the middle of our conversation about the Constitution. We're going through, as you know, this book, The Constitution Today, chapter by chapter. We've talked about the presidency, and remember one theme that I had, and at every point I'm trying to show you the relevance, the ongoing relevance of the Constitution. The Constitution Today, and I'm actually in this conversation often trying to connect the themes of the Constitution to stuff that's happening even after the publication of this book. So chapter 1 is about presidency, and I told you the 35-year-old idea is all about dynasty, and what did we see yesterday? But discussed, you saw the families on full display, and so that theme continues, you see, into the modern era. Chapter 2 is about the Vice Presidency. We had a vice presidential debate, indeed, since we've last met, I published an op-ed. I published two, but one is on a website called Vox, vox.com. It's a site created by the great Ezra Klein, a preeminent journalist. And I published this the day before all heck broke loose. That was Friday. But I published a piece explaining how even at this late date, Mike Pence can knock Trump off the ticket, in effect. And this is all about the relationship between presidents and vice presidents. It's about some of the themes of the 25th Amendment that are actually in that chapter. And in the Q&A, if you want me to explain how that whole thing works, I'd be delighted to do it. Happy to have you read that piece, but it's an absolute, perfect, frankly, continuation of the themes in this chapter, chapter 2, which are all about interesting aspects of the 25th Amendment, which is about the relationship between the presidency and the vice presidency, especially as redefined in the aftermath of the Kennedy assassination and Lyndon Johnson's ascension to the presidency. So that was chapter 2. Chapter 3 is about congressional dysfunction, and in particular the Senate filibuster and how it could be reformed. And indeed, that's a theme prominently on display even in yesterday's debate, in that if Donald Trump wins and carries the Senate, I think it's less likely today than it was when we last met, but it's still a possibility. People, all the people haven't voted yet, although early voting has already started in some places. But if Donald Trump wins, he will carry the Senate, presumably, and if he does that, his party will have a Senate majority, but not a filibuster-proof majority. So is he guaranteed of getting a Supreme Court pick to his liking, someone off the 20? I believe he is, because at any moment the Senate would be allowed by simple majority votes to get rid of the filibuster for Supreme Court justices, using the same theory that they use to modify the filibuster for other appointments, a theory that's at the very center of Chapter 3, frankly, a theory that I kind of unleashed on the world and is now being taken seriously in the same way that this Vox idea, like a mad scientist creating these viruses and then recombinant DNA and then unleashing them into the world. But if Trump wins, he will carry the Senate, and they can change the rules and get a Supreme Court nominee as long as 51 Republicans were to agree. Contrary-wise, if Hillary Clinton wins, she likely carries the Senate, and she would be allowed to fill that vacancy. And that vacancy was, if not front and center, at least explicitly addressed at the end of yesterday's debate. So I say all this to try to remind us all that these essays genuinely are trying to explain what a document first adopted 230 years ago and then continually amended and lost in the intervening centuries has supreme relevance to some of the biggest issues, literally, that we're talking about today. This week, yesterday's debate, the Scalia vacancy and its connection to the filibuster, the relationship between presidents and vice presidents and even running mates, and you saw a little bit of tension because Pence didn't quite defend Trump, and then Trump didn't quite defend Pence, and I was trying to make a little mischief in the whole thing, saying Pence could actually push Trump off the stage if he had the guts to do so, and he would need the backing of two key people, as I explained, Paul Ryan and Mitch McConnell, but he doesn't need the backing of the Republican National Committee, for example, the Republican establishment as such, just those two people. And again, I'm happy to tell you all about that. First chapter and its discussion of dynasty, and we heard about, you see the relationship between Bill and Hillary yesterday, and we saw the children on display. So these are genuinely relevant themes. And so with the chapter that we focus on today, it's a chapter called Who Judges the Judges? Because we talked about the presidency, we talked about the vice presidency, we talked about fixing the dysfunctional Congress, especially the Senate filibuster process. This is a chapter on the judiciary. Who judges the judges? And the answer in the word is we, the people of the United States. You might think that the Supreme Court is supreme over the entire system, over the other branches, over the Constitution. I don't think any of that, and I hope you don't either, because if that were true, then the court, in effect, would be a law unto itself. Anything it said, we'd all have to bow to, and that can't be right. It has to be an external standard against which, called law, we measure the court itself, such that it's possible to say the court got it wrong. And on what ground do you say that with some authority? That's the ground of the Constitution itself. As Lincoln, for example, said after Dred Scott, he said that an opinion was, quote, an astonisher in legal history. And he had arguments that it's textually unjustified and historically it's preposterous, and there are no precedents that really support it, and it's a partisan decision. And history today, I think, sides with Lincoln as against the Supreme Court. In a case called Plessy versus Ferguson, the vote is 8-1, and John Marshall Harlan, alone in dissent, says, "You 8 are wrong. You're as wrong as it's possible to be. You're wrong in the way that the Dred Scott court was wrong." He says all of that. It's a pretty audacious thing for someone to say alone in dissent. And yet history, I think, has vindicated that John Marshall Harlan, the elder, dissent. His grandson, the same name, was an Eisenhower appointee to the court. Now, why is it possible for someone to say that? Because the Constitution isn't just what the judges say it is. It has a reality of its own. And what I explain in this chapter is I see my job as involving, it's chutzpah, in a way, but I'm paid in part to the niche that I fill in part involves evaluating what the judges have said. And if they say something very plausible, trying to take what they've said and make that more accessible to my fellow citizens, because they're writing sometimes in a slightly more technical register. And so if I agree with them, I try to explain to my fellow citizens why this makes sense, why the dissenters are wrong, because the dissenters might not have been persuaded, how perhaps the court is right in the result, but it could have perhaps articulated its reasoning in a somewhat more persuasive way. That's kind of my job. And who judges me? Well, ultimately, the citizenry and history. So I have, incentives to try to evaluate, to judge the judges, to referee the refs, using, I see my friend who's just arrived here, what my friend Philip Bobbitt, who's just arriving, calls the modalities of constitutional argumentation, by reference to constitutional text, the original intent behind a constitutional provision, the structure of the Constitution as a whole, various precedents that pre-existed this most recent decision, which in turn, if it's really proper law, has to be a precedent for later decisions involving different parties. So there is, Philip, I was just explaining to our friends that the Constitution isn't just what the courts say it is, even the Supreme Court says it is. That ultimately, judges are judged by their conformity with legal tools and techniques of argumentation, and in particular constitutional tools and techniques of argumentation. And what it is that Philip Bobbitt does, he's just joined me, he's my co-teacher at Columbia and Yale Law Schools. What it is that I do, it's cheeky to some extent, in a way. It's presumptuous in that we presume to actually analyze what the judges do, and often say, this makes sense, here's why. Or the result is right, but here's maybe a slightly better way of putting it. Or sometimes saying, we respectfully disagree. Sometimes saying, this is preposterous, this is an astonishing in legal history. And ultimately, see, we're not the last word either. Ultimately, history is, and in the first instance, you, our fellow citizens, are the audience. In the same way, an analogy is, since John Roberts, the current Chief Justice, very famously analogized the role of the judge to the umpire. Well, you might think of us as the commentators who have access to slow motion, multiple angle cameras. So we actually, the call is made by the umpire on the field, and then, because we have the luxury of time, judges all have to decide things often in very quick fashion. We slow it down, we take a look at it from different multiple camera angles and try to decide, in effect, whether the home plate umpire blew the call or nailed it. So with that general background, so the bottom, the one word, the one-line answer to the question posed by Chapter 4, who judges the judges, is ultimately all of us, a sovereign citizenry, but we can't do that unless we have some sense of how you do constitutional law, what various tools and techniques of constitutional argumentation might be. Ultimately, history judges us all. It keeps, I hope, us honest. One of the themes of this book is, look, here's something I said 20 years ago. Does it still stand up? Do you still think now that all the spin cycles have run their course, that the particular partisan currents have subsided? Does this make sense in the coolness of time? So I begin with a couple of essays on how the court administers itself. The issue in particular of cameras in the court, or the openness of the Supreme Court. And I begin with a couple of essays that were critical of court practices about 15 years ago. Here were the rules 15 years ago. People were not allowed, when the court was sitting in open court, hearing oral arguments between the advocates and with a colloquy conversation with the justices, asking them questions. Open court, anyone in Washington, D.C. could come into the building, could draw an eye and could hear the proceedings. But if you did so, you weren't allowed, in general, if you were sitting in the audience, to take a pen out and write something down on a piece of paper about what a justice said or what an advocate said. Note-taking was actually prohibited. which seemed to me preposterous. We're paying for that whole venue. The sovereign citizenry. It wasn't a safety issue because you were allowed to take a pen and stick it in your hair as a chopstick for your hairdo, or to clean out your ears. It wasn't a safety issue at all. No, you just could not engage in the communicative act of writing something down, of thinking about what you just heard and jotting down a thought. And my claim was the only place in America where that kind of prohibition it could be upheld is in the court itself, because they would never allow any other branch of government under their own free speech doctrines to discriminate against communication as such, to the act of writing. And so I was very critical in an op-ed in the New York Times, and one that I followed up with, and I brought to my fellow citizens some facts. No other court in America, no state court had that kind of rule. The state Supreme Court, no lower federal court had that kind of rule. None of the other courts, so far as I was able to determine, around the world had anything like that. Again, the court doesn't really, if you took seriously what it says about freedom of speech in other parts of the government. So I said, this really can't stand. It's wrong. To show that this wasn't a partisan thought on my part, it was very important that I have a co-author. His name is, on that project, his name is Steve Calabrese. He is one of the founders, of the three co-founders of the Federalist Society. He clerked for Robert Bork and later Antonin Scalia. An absolute, perfectly credentialed conservative. I clerked way back when he was on the First Circuit for Stephen Breyer. And we wrote it together precisely to show this is not some partisan thing, we just think it's kind of preposterous. Happy to report the court has changed its practice. And now you can take notes. Not just if you're a lawyer in the bar, not just if you're an official member of the press corps, but just a member of the sovereign citizenry who wants to participate. We further criticized the fact that at the time, the court was not making transcripts of the discourse in open court available in a free and timely fashion to the public. We said at a minimum, there should be a transcription and it should be posted online, in effect, within a day or two or three. And today, the court does that. We went further and we say, there's actually no good argument for at least not having an audio tape of the court proceeding that could be uploaded, either live or with a bit of delay on NPR or on C-SPAN. That's how many other courts operate in America, and you're entitled to that. The court hasn't gone that far across the board yet, but it has done that for certain very prominent cases, like the Obamacare case, for example. Our broadest suggestion was television cameras in the courtroom. That's not going to, I think, happen anytime soon. What's the difference between audio tape and videotape? Frankly, I think the difference is that the justices value very much their anonymity, their privacy. They like the fact that when they go to the grocery store, they're not always sort of recognizable. And an audio tape preserves that. A video would make them a little bit more likely to be noticed, and so they're going to resist that, frankly. And they're going to say all sorts of things that maybe are not fully plausible. Many Supreme Courts around the world, the Canadian Supreme Court has its proceedings on Canada's version of C-SPAN. Many courts of appeals actually have public video. Many state Supreme Courts do the same. But I don't see that happening, but my compromise that I put forth, that Steve Calabrese and I put forth, was audio tape. Now let me take a step back and connect that, and I'll tell you about two more things: Bush versus Gore, and the Garland, the Scalia vacancy, and then let's have a conversation. The court just yesterday, just trying to connect what I just said, because this is, it promises, this is lectures on the Constitution today. What's the relevance of that to stuff right now? Well, here's one. There was an exchange yesterday about public versus private, things you say in public and things you say in private. And what Hillary Clinton said is there's actually a need, sort of Ecclesiastes, to everything there's a season. Some things actually are private and some things are public, and you can't do everything in public, and that's not a bug, that's a feature, that's actually a good thing, and we shouldn't lose it. I actually agree. I'll give you some examples using Article 3. Here's what I'm not proposing: that there be an audio tape or cameras or a transcript when the justices are talking among themselves after the oral argument, when they're thinking about their initial votes, when they're in chambers batting ideas back and forth to the law clerk. That's private, and I actually do not propose that we have cameras and stenographers and audio tape there. So, Professor, what's the difference between that and the oral argument? Because the oral argument is, by its nature, public. There are people there. Anyone in Washington, D.C. can be there. It just seems wrong that D.C. people can see it and NYC people can't. But what's up with that? That's a kind of geographic discrimination that, if technology doesn't permit NYC people to see it, well, that's one thing, or to hear it. But why should the folks who just happen to be geographically proximate have a right to hear with their own ears, at least, what's happening in open court, as opposed to the rest of us? And when the court gives its statement of reasons, its opinion, that's public. And we can have at it, and I'll write an op-ed, and I'll say I agree or I disagree. So oral argument is public, and the ultimate statement of reasons is public, but in between, there actually is properly a space for something more private. Why shouldn't we have access when the judge is talking to law? Maybe it's all corrupt. Maybe the whole system is rigged, Donald Trump would say. When the justices are talking to themselves, well, maybe, but also people earnestly and honestly trying to do their job, public servants, actually might need a space to float, for example, ideas back and forth. And they might be hesitant to do so. Well, here's a legal theory. What do you think about it? Sometimes you don't know if it makes sense until you write it up, until you actually, that's how we think. We write something up, we make an argument, say, look, I'm not sure this is right, but suppose I said that, and then get reactions. And that process is very important. It's how we actually figure out what's right. And it would be chilled to an important extent if all of those early conversations had to be public the way the oral argument is. My claim is oral argument is already public. Let's just bring in the whole public. Here are examples of things, and Hillary Clinton was actually saying, not everything that occurs in private conversation is illegitimate. But it might very well be that when Lincoln is trying to persuade someone to vote for the 13th Amendment, he makes a certain argument that, and at the end of the day, he will make a public argument for why he believes in the 13th Amendment, but it might very well be that, that not everything that he says to every person is ultimately sensibly part of his public defense of the 13th Amendment. So a judge might say, for example, listen, I think the plaintiff should win for two reasons. For reason A and for reason B. And it turns out all 9 judges agree with A. Only 5 of the justices agree with B. A justice might say, you know, I have 5 votes for B. I could jam it, but I prefer to do things by consensus. Let me simply decide the case on ground A. We're all unanimous about that. Red and blue, Democrat appointees and Republican appointees, and we can revisit the other issue if and when it arises in a later case. Now, there's nothing illegitimate about that, nor is there anything illegitimate if a judge says, I actually, want to make an argument for A and B, and I'll get 9 votes for A and 5 for B. But a lot of the give and take, that must needs be private at first. Someone might circulate an opinion to her colleagues, and someone writes back saying, I'll join your opinion, but only if you take out footnote 7. And footnote 7 perhaps is not necessary in any way to the disposition of the case, so footnote 7 is taken out, and I don't think the give and take, the honest exchange among the justices could happen with the same kind of candor and collegiality and willingness to sometimes float an idea and then retract it if that all had to be public. And I'll give you an example of something that probably could never have happened if every preliminary part of the process had to be public. It's called the Constitution of the United States. I hope you've heard of it. At the end of the day, George Washington and Ben Franklin and the others had to stand by this public proposal that they made. But before the proposal, and they gave public reasons in the ratifying conventions, in pamphlets, some of which were anonymous, others of which bore openly the names of the authors. The Federalist Papers were actually anonymous, but reasons are given publicly, again, sometimes anonymously, sometimes not. But all the give and take, the back and forth that occurred in the hammering out of the final proposal, that was private. And I don't think that there's always something wrong with having a private portion alongside a public portion of public policy development. And that's actually, I think, part of what Hillary Clinton was saying last night. That even Lincoln did certain things in private, and nothing wrong with that necessarily. Nothing wrong with that necessarily. And he had, in response, a kind of Lloyd Benson moment when, in fact, he said, you're no Abe Lincoln. And we have Abe right here to remind us of just how towering a figure he was. But he wasn't above, truth be told, twisting a few arms and cajoling and sweet talking. And he did so in the service of a very great cause. I'll say one other thing, and then I'll talk about Bush versus Gore, and then the Garland nomination. A century after Lincoln did all these things, President Lyndon Johnson used all the arts of persuasion, some public, some private, to get through landmark pieces of legislation that have defined the modern world. The Civil Rights Act of 1964, the Voting Rights Act of 1965. The movie that she alluded to, the Spielberg movie, Lincoln, was based in part, it was in collaboration with Doris Kearns Goodwin, team of rivals. And this is democracy at work, you see, because there's actually, with a crowd, often wisdom that any individual lacks. I've been telling you that. That's actually what we small d Democrats believe. So Doris Kearns Goodwin was sort of the advisor to the Lincoln movie. Her very first book is actually called Lyndon Johnson and the American Dream, and I think in some very interesting ways, actually, she presents Lincoln as similar to Lyndon in certain very interesting ways, sort of the master of the Senate, so to speak, using arts of cajolery and all this. And so not all things properly take place in public. True of the Constitution, true of the courts, true of the 13th Amendment, and you saw a tiny little snippet of that last night. Okay. But for oral argument, I said it's already in public, let all of us in. The court has already decided that's a public part of the process. Bush versus Gore, very briefly. I talk about it, and I claim and I said in real time that it was a disgrace. And I have a couple of reasons, and I'll tell you about them, and then we'll move to the Garland vacancy, and then we can have a conversation. In my version of the Constitution, presidents pick justices, and justices aren't supposed to pick presidents. We pick presidents, we pick senators and citizenry, and they in turn pick the justices. The justices don't pick their own. The House picks Paul Ryan as the head of the House. The Senate picks Mitch McConnell as the head of the Senate. The justices themselves do not pick John Roberts. Presidents get to pick their lieutenants, their cabinet officers. Donald Trump said that he was going to instruct his attorney general to do thus and such. Okay? Because he's going to pick his attorney general, and he's going to tell his attorney general what to do in certain situations. He said instruct, but we don't let the justices pick the lower court judges, who are their assistants in some way. That's not our system. It could be, but it's not. Ours is a system in which basically more democratic branches pick less democratic branches. Presidents pick justices, justices don't pick presidents. So my first objection to Bush versus Gore, the court got involved in this at all because in my copy of the Constitution, contested electoral college issues are to be resolved by the Congress of the United States. They're the constitutional adjudicator. And so this is the political question doctrine. I have one of my Columbia Law students here. So this is what we were talking about earlier today. What are my precedents for such an assertion? I made a structural argument about democracy. And I could make a textual argument that when you look at the text of the Constitution, it says the electoral votes are to be counted in the Congress, and so presumably that's the place that's supposed to resolve any disputes. That's my textual argument. So a structural argument about democracy, a textual argument about the language of Article 2 and where the ballots are supposed to be counted. And now let me give you just the precedents. The precedents here are the precedents of prior contested presidential elections. And in 1800, 1801, that was between Jefferson and Burr against John Adams, and that was resolved in Congress itself. And in 1824, 1825, Andrew Jackson and John Quincy Adams and others, and that was resolved in Congress itself. And in 1876, 77, the Hayes-Tilden election, again involving an electoral college contest with a connection to New York. Actually, Samuel J. Tilden, I think, had a connection to this state, and that was resolved by Congress. Some justices were asked to intervene, but not qua Supreme Court. They were actually, in effect, like arbitrators or something, helping Congress out at Congress's invitation. But in none of those episodes of the Supreme Court as such, or any other court, they presume to intervene and say, we're going to decide it. So I think the court was wrong in hearing the case, in grabbing to itself this decision. What it said on the merits, I thought was preposterous. There was an argument about Article 2, and an argument about equal protection, and I think both things that the court said there were implausible for reasons I explain in the chapter. And in any event, if the court was going to intervene this way, I think it had a duty to be non-partisan. Maybe five have to beat the force, which you heard that I believe in majority rule, and you believe in majority rule in the House and the Senate and the court itself. There's nothing in the Constitution that says five have to beat the four, but it's just in the nature of things. It must needs be so that the majority naturally determines the whole. But it shouldn't be a partisan point. If you are going to intervene in this way, it's very important, I think, for the legitimacy of the court that you have basically people across the aisle on the judiciary joining hands, and that's what you didn't have there. Presidential elections are referenda on the court itself, you see. It's one of the structural checks on the judiciary itself, as is impeachment, for example. We pick presidents in part so that they will replenish the court. And it was deeply disheartening that the judges whom George W. Bush had praised, sided with George W. Bush, and the judges the justices whom Al Gore had in effect praised, saying, I want more like that, sided with Al Gore. The justices, in effect, by picking a president, not only were they picking their own successors and lower court judges by all of that, they shouldn't have intervened at all, but if they did, they had a duty to be nonpartisan, and they weren't. And what they said, as I said, was preposterous, and they even said, this isn't really a precedent for any future case. Don't try this at home, any other judge. But announcing in advance that not only that they really weren't being bound by any past precedent, because no past precedent was remotely like this one, but going forward, they weren't willing to bind themselves to what Herbert Wechsler, a famous professor at Columbia, very famously called neutral principles, principles that would apply in the next case even if the parties were reversed. And part of the rule of law is that you have principles that apply regardless of the identity of the parties. The justice is blind in that sense. She's holding a scale, and she's not really supposed to know, whose ox is gored, so to speak, or whose gore is ox, or whatever. Okay, so I was pretty critical of the court on its policies of not being as open as it should be, and it's gotten better. Very critical at the time of Bush versus Gore. I said it's preposterous and astonisher, and I think that judgment of Bush versus Gore has aged pretty well. People who defended the decision at the time now admit that it really isn't particularly defensible. Even, I think, some of the justices who got caught up in the passions of the moment regret that decision, at least privately. I can report to you that that's at least what I've been told by reliable sources. And if you know the modalities of constitutional argumentation, you don't have to wait 10, 20 years. You can see some of this at the time, because you can measure it against constitutional text and constitutional precedents and constitutional structure. Okay, finally, just I have a couple of essays in the chapter on the vacancy created by Justice Scalia's demise, and the Garland and Merrick Garland as the replacement. I'm happy in the Q&A to talk about whether he deserves a hearing or not. I talk a little bit about that in the piece, but let me just, because I want to quickly get into Q&A. Let me just tell you briefly about another interesting element that I think is visible in the Garland, the choice of Merrick Garland. And it connects to some deep fissures in American society that were also on display yesterday. Here's a fault line between the educated elite and the less highly educated citizenry. Now, every single member, I point out in this short piece, of today's Supreme Court is a graduate of Harvard, Yale, Columbia Law Schools. Actually, and Ruth Bader Ginsburg went to Harvard. So they all went to Harvard or Yale, two schools. Merrick Garland went to Harvard College and Harvard Law School. And there's something admirable about that, because our great schools are no longer limited just to the people who are born with wealth or power or fame. They're open to the likes of Barack Obama, Sonia Sotomayor, Clarence Thomas, a scholarship kid like Merrick Garland. So there's something kind of admirable about that. And I also say, these are very hardworking people. Barack Obama, Hillary Clinton, Merrick Garland. They all have a connection to Illinois. They all descend from Lincoln in some obvious sense. They're hard-working, low-born folks with some connection to Illinois. And Obama mentions the land of Lincoln and the Rose Garden when he introduces Merrick Garland to America. Merrick Garland is, I argue, kind of Hillary Clinton without the baggage. And there's something Lincolnian about this, these low-born folk who work very hard. But Abraham Lincoln had less than a year's formal education in his whole life. And he had a connection to common folk, and today's citizenry is deeply skeptical of an elite, an educational elite, an economic elite, and you saw some of that on display yesterday. She knows her stuff. He doesn't. Okay, so that's the good side of modern meritocracy. She's actually done her homework. Okay, but there's this other side that your fate in life is determined way too early by which school you attended, and if you didn't go to one of these places, you could never, in today's world, aspire to the highest rung, and that breeds lots of resentment, in the sense that these elites have fashion rules in their own interest. It turns out to be good for me personally if they all have to go to Harvard and Yale law schools, because I teach at these places. I don't think it's great for the country, perhaps, to have so narrow a gateway. Even though it might be to my advantage that 3 of my students are senators of the United States already. Mike Bennett, Chris Coons, Cory Booker. But is that in the broader national interest? How many of the last 4 presidents of the United States went to Harvard or Yale or both? 4. If Hillary wins, that would be 5. How many of the last 7, and I talk about this in the chapter, it's not dynasty quite, it's different, it's meritocracy, but it still makes me a little uneasy, even as I've hugely benefited from it. How many of the last 7 runners-up went to Harvard or Yale for the presidency, or both? 5 of the last 7 runners-up. Hillary would make, and Trump didn't go to those schools, but he did go to Wharton. It's an Ivy League place. My friend Philip is a Princetonian, so he might be feeling left out a little bit here, so I need to bring Princeton into the picture. Since Teddy Roosevelt, the last 19 presidents, 10 of them, went to Harvard, Yale, Columbia, or Princeton. Just 4 schools. And that's not counting Dwight Eisenhower, who later became president of Columbia. And the ones who didn't, well, we're talking, among others, about an Amherst grad, Calvin Coolidge, or a Stanford grad, Herbert Hoover, or an Annapolis grad, or West Point grad, Carter, or that's interesting, and maybe troubling. In 20 of the last 28 presidential contests, either the winner or the runner-up went to one of those 4 schools. The last time, if you include vice presidential candidates in the mix, the last time that none of the top 4, the 2 people who won and the 2 people who ran against them, that none of the 4 went to just Harvard or Yale, none of the top 4, you'd have to go back to 1968. And that was a year when Bobby Kennedy, if he hadn't been killed before our eyes, I think would have won. He's a Harvard person. When Richard Nixon did win, although he didn't go to Harvard, he had been admitted to Harvard on a scholarship, but not a big enough scholarship, and he couldn't afford it. And back in those days, Harvard wasn't as generous in scholarship as it is today, as Princeton is today, as Yale is today, more open to the likes of a Sonia Sotomayor, a Clarence Thomas, a Barack Obama. We are, so it's not dynastic, but there are these deep fissures in America between elites and non-elites, and you saw some of that on display yesterday as well. And so I'm trying to sort of bring to the surface themes that are genuinely relevant to the Constitution. And with that, I bid you all a good night and see you next week.